Okay, I'm back today. Okay, I'm back. This is a call-in show. It's a call-in show. Phone lines are open. Phone lines are open. Phone lines are open. I ain't gonna say nothing. I'm just waiting for the phone calls to come in. Ooh, baby, I like it raw. Ooh, baby, I like it raw. Mission be you. Let's see where we at. Okay, there we go. All right, calling numbers 404-948-5610. 404 is right there in the description. 404 948 5610. Phone lines open. Mhm. Mhm. Yeah, I'm back. I had some time. I got time today, so I opened up the phone lines. I got time today. Phone lines are open. I'm waiting on some things, so yeah, I got time today. I'm back. What's good, brother? I'm about to dial, but I'm at work pressing close. Hi. I'm at work too. I'm at work right now. This is my job. I'm at work. Man, that damn video looks so good, don't it? That looks so good. I'm gonna stick with this right here. I tried the other lens. I like this right here. The settings on this are nice. It's nice. It's warm. It looks very professional. Oh, somebody on hold? Okay, hold on. Let me see. Somebody said they on hold. Let me see who's on hold. Oh, damn, boy, a lot of people called in. Shit. Let me go to Georgia, 678-6117. You on the line.
Hey, how's it going?
I'm doing fine. How about yourself?
Pretty good.
All right, all right, all right. What you got for me
Well,
today?
so it's been a minute. So I wanted to ask the question: if you've already prepared instruments and things like that in your trust, but you really need someone to review them and look over them, and you might not be in a situation where you can join one of the master classes. what's the best route to go?
Well, I mean, you could have came to SBC University. A lot of people come to SBC University and have me review their trust. Matter of fact, the whole class that we're conducting right now is because somebody brought their trust to class and let me review it. We reviewed it in front of the entire class, and it was definitely not a very good trust. Just because you say you have a trust doesn't mean you have a good
Okay.
one. And but yeah, we reviewed it, and now we're constructing one. We're reconstructing it, and we're going line by line and clause by clause and reconstructing it and reading the case law based off case law. But
Right.
or
I
get a
understand that.
or get you a consultation. That's
Because
another fast way of doing it as well. You get a consultation with myself or Mr. Brewer, and I'm sure he'd be happy to look over your paperwork to see if it's in compliance. You know, if we're talking about private placement memorandums and things of that nature, but if we're talking about a private trust, yes, I can look over it. That's not a problem.
right.
Okay.
Well, yeah, I was looking more into the PPM. I did catch the lives with you and Mr. Brewer, and I was wondering what would be a good contact. I know you guys sent the email out, so I do have the email. So I didn't want to just, you know, send an email without at least speaking to you. And I've had a consult with you before.
I mean, if you're talking about private placement memorandums, there's only two ways you're going to get in touch with Mr. Brewer. You can attend his class, or you could do a private consultation with him. Is that
Okay.
the
So
answer?
how would I go about doing a private consultation?
Well, I can get in touch with him and see. Send an email to admin at SPC University. No, send it to support at spcuniversity.com and say that you'd like to get in touch with him. We'll forward the
Yes.
information to
Thank
him.
you so much.
Make sure he gets it. We actually devoted 8-week course. We got an email
Okay,
devoted.
that's great. Thank you so much.
Okay. Okay. All right. Well, appreciate it. Thank you for calling in. We'll go to the next caller. What area code is this? Let me move these area codes in here. Let me get these things up. All right, so we're gallivanting around the country. Let's stop in area code. Let's go over to area code 904. Let's talk to Florida. 9794, you're on the line.
Yeah, how you doing? Peace to the God.
Peace, God. How you doing?
All right, my son. First and foremost, sir, are we on a topic today? Because I don't want to be talking off topic.
No, no, it's not on any particular topic. I'm just answering questions.
Okay, okay. First and foremost, I'd like for you to know that if it was for your what is it? Expertise, I'd be in prison right now today, sir.
I appreciate it.
I came up.
And let me
Yes,
pause.
sir.
Let me pause for a second. I just want to acknowledge. I want to thank you also for that. But I get a lot of people tell me that all the time. But it's always people saying that, oh, show me some proof your stuff works and things like that. I get calls like that all the time for the last almost the entire 20 years I've been doing this. People have been telling me this, but
I know.
they think because I don't parade people in front of them and say, here, look, here are all the people that I helped. And, I don't do that. So your stuff must not work. But I appreciate that, brother. I appreciate that. Go ahead.
Well, sir, I have evidence. My name is Brian Keith Jemison Sr., and you can Google my name at Jacksonville Beach, Florida. I went through two cases. both of them were gun charges, and one of them was on the news. So there's a news article with my name at Jacksonville Beach. Just look up my name at Jacksonville Beach, and there's your evidence. All you need to know. So with that said, my problem today is, to make a long story short, CPS took my grandkids. With that said, they're not responding like they're supposed to professionally and things of that nature. And I'm trying to figure out what avenues I could possibly take other than having to get a lawyer, because both of these cases that I went through, I represented myself. So with that said, I like to handle it myself because I think I'm capable of it. And I'm just trying to figure out, is this I don't want to have to consult a lawyer, but I am reading the laws of CPS, and what they're stating and what's happening to me is a violation of my rights. And would I come out okay if I filed in 1983, 42?
Well, I mean, let's back up. First of all, Child Protective Services came and got the children, and okay, so that means that there was some sort of allegations of abuse. Am I not correct? Is that not correct?
That's correct.
Okay,
that's
allegations.
Correct. But the only thing is,
go ahead, I'm listening.
But there are no allegations. I haven't gotten any allegations. What I'm trying to ask them what the problem was that you would come get my grandkids. They were in no imminent danger. There were no extenuating circumstances whatsoever. The kids were with their grandmother, and the grandmother had the grandmother's sister that came and got them for the day or whatever case may be, and then they came and got them from home. You know, and at the same time, my daughter, she's incarcerated, the kid's mother. Okay. Now, with that said, while she was incarcerated, I helped her get a power of attorney to her mother, who was, the kid's grandmother. So she had custody of the kids by power of attorney when they came and got them, but they were in no danger, and that's one of the criteria that they said that they required. That was required.
Well, my next question would be, well, who called Child Protective Services on them? There's a reason I'm asking these questions before I answer. Okay,
yes, sir.
Who called Child Protective Services?
Okay, Child Protective Services were not called. What happened was, me and my daughter got in a dispute, and she ended up going to jail. When she went to jail, the kids were there with her mother, who was their grandmother, and they were in my daughter's home. Okay, so that lasted about a couple of weeks, and then all of a sudden they just came and got them. No imminent danger. No,
really, there's going to be a reason. I mean, for me to even do anything, I'd have to look at the paperwork. I'm sure there's a case filed. I'm sure there's an affidavit that has to be on file somewhere by one of the officers that represent Child Protective Services. But usually when children are taken, they got this video on YouTube. It's called Judges Slush Fund, and that's Dr. Shirley.
Judges Slush Fund?
Yeah, Judges Slush Fund, and the woman's name is Dr. Shirley Moore. I think that's her name. Let me go. Judges Slush Fund. I'm going to put it on the screen for everybody to see. It's a video.
Mm-hmm.
Been on the internet for a very, very long time. And what this video is about, I interviewed this lady, as a matter of fact. She came over to my website and I interviewed her. But what was it? It was about Child Protective Services. And the allegation was that Child Protective Services was kidnapping children. And they had evidence of it.
They are.
Yeah, they kidnap, and that's why I'm asking the questions. Let me put this on the screen so everybody can see it real quick. This is called the Judges Slush Fund. Let me see, no screen. Put it on the screen for everybody.
Now,
okay,
also
okay, hold on. Let me finish this. Right here, y'all see this?
Mm-hmm.
This right here, William Wagner. Now, what happened to it? What did I just do with it? Yeah, William Wagner right here. It's 3 parts to it. But this video right here
either.
which is a video
And
a
so
lot
we're
of people
talking
do not
about,
pay attention to. There's 3 parts to it. Judges Slush Fund, there's a part 1, part 2, part 3. What this lady, she took on Child Protective Services in California. And what was found was that Child Protective Services were using x-rays and saying that the children had been hurt or something like that, but they were using the exact same x-ray, and they used it like on about 200 different cases or something like that. And also we have that senator up in that came up dead in Ohio, who was also investigating Child Protective Services. So in no kind of way am I going to discount that Child Protective Services may be involved in some sort of kidnapping of children. We have the allegations of adrenochrome and all of that going on in the background. There's a lot of this stuff going around surrounding children. However, I also do know that I have personally witnessed situations where Child Protective Services have been called, and I think that it has been merited and it's been warranted. And that's why I was asking the particular questions. Did the children call Child Protective Services? Did a neighbor? Did another family member? See, all those things are important, because I understand that it could be, they just came and swiped up the children. That's always a possibility. I'm not saying that it's not. But however, I always have to consider the fact that, okay, was this in the best interest of the children? Was there some sort of abuse going on? I have to find that out first. Now, that's looking at the paperwork. Now, I'm going to proceed from here as if abuse was not happening. Okay, so if there was no abuse in place, okay, I would, first of all, have you been documenting everything? All right. In other words, if you've been contacting them, certified mail with an affidavit of mailing, requesting that they provide you with some, and I would also put in my documentation some sort of verification of I am a relation to the children, I'm extended family, because usually they will give, if the parents were abusing the children, the grandparents can apply for custody and they can get the custody of the children. I don't understand why that can't be done.
This is what I'm in the process,
Yeah,
this is what I'm in the process of trying to do.
Yeah, they can do that too. So I'm not really sure about the circumstances around it. However, it seems that you're saying that there was no abuse in place. At this point, you have to go through the procedure. Obviously, they are in the custody of the public officials. So you're going to have to go through whatever process they want you to go through to get them back. There's not some magic process where you're going to put liens on people and force them to cough up the children or something like that. I've never seen that happen. What I have seen happen is people, they sue them and make them come into court and present their evidence. And so, I would probably sue them.
That's what I'm in the part. That's what I want to do. Because there is no evidence.
Yeah, I would hit them.
I
would hit them
whatsoever.
I would hit them with some sort of, evidence is also sworn statements. So that's why I was asking, was there anyone who reported it? Because sworn statements are evidence as well. So without really being able to look at the discovery and see, I couldn't, everything would just be speculation at this point. But is there a way? Yeah, there's a way that you can do things. You can sue them and bring them into court and make them present their case and present their evidence. Are they just holding the children? They haven't contacted anybody and told them what they need to do to get the children back?
That's what I'm trying, sir. That's what I've been trying to say. I've been contacting them. I've been calling them people every day. They don't answer the phone. They will not return your phone call.
At this point, you don't, when you're getting ready to go to court, you don't make phone calls. You send written letters. You send written correspondence. That's what you need to do. You need to send something certified mail with an affidavit of mailing. They won't respond.
Yes, sir.
And then,
now I get it.
And then also you need to be able to identify. I would study all the state statutes for in your state for Child Protective Services.
That's what I'm doing.
And then find out
and I'm going by case law. And I'm looking up the case law. Yes, sir.
What information that they are supposed. I would run it through a ChatGPT, and that gets you all the answers right off the bat. But see, what I would really do.
I've been getting a lot of answers.
I would take the affidavit, which is the warrant or whatever it is that they use to come and get the order that allowed them to come and pick up the children, and I'd run that through ChatGPT and ask what remedies are afforded to me in this particular state. And ChatGPT is going to give you every option that's going to be available to you, every option, and it's going to be a lot. It's going to be a lot. Trust me.
Okay. Well, would you agree with you know, when I get this information and I put it down on paper and put it in affidavit form and send it certified mail and things of this nature. With that said, I mean, the evidence. I asked the lady where was the evidence, and you know what she told me? She said that since you're not a party to the case, she couldn't give me that information. I said, well, I'm the grandfather. I mean, what's going on? You know, I'm the reason. Actually, sir, I'm the reason the kids are in protective custody because I told my daughter, I said, I don't want you hitting on the boy like that. I don't do that to him. You know what I'm saying?
And that's probably
But
why
we
they
got into an argument.
that's probably why they called him. That's what I was about to say. You know, I've had friends of
Yes,
mine.
sir.
You know, Child Protective Services come and ask me, are they abusive? And I told them no, because you know it's my friend and everything, because he's not killing his children or anything.
Right.
But at the same time,
Right.
I thought he was over abusive. I thought he was verbally abusive. I don't know if he was physically abusive,
Right.
but I know and children didn't want to be around him. All right, so but he's
Right.
in denial. A lot of times, parents be in denial. They be abusing their children, and they be in denial. They be in denial, like I'm not
Yeah,
abusing them.
exactly.
Yes, you are abusing them. You know, you're abusing them. You're verbally
Yes.
abusing them,
Yes.
and you know, and physically abusing the child. So, like I said,
Exactly.
that right there, they're gonna do whatever is in the best interest of the child. So when you approach it, that is what you need to do. You need to make them understand, well, the best interest of this child is being with their grandparents, and you need to be able to demonstrate that with extended family, showing
Exactly.
that you have an environment that those children can be placed in where they're going to be safe and they're going to be taken care of. So that's what I would say
Okay.
first and foremost. And I'm just doing this from experience because I get people, you know, come at me all the time like that. But I'm always have to do this balancing
Mhm.
act because I have seen cases of abuse and I've seen cases where the kids
Right.
have been, in my opinion, kidnapped, you know. But in either
Mhm.
way, somebody needs to present some sort of evidence, a delegation of authority. That's the first thing. They need to show me where they got the delegation of authority. Take your children and cite
Well,
all of
as a
the.
grandfather, but as a grandfather, don't I have a right to know what the situation of the case, the status of the case, and things of this nature? I
I
look
don't
at
know.
it
I
up
don't
at
know
that
what
too. I
I don't
mean,
know what the state.
I don't have the rights.
I don't
I
know
don't
what
have the
the
rights of a parent.
I don't know what the state
Uh-huh.
statute is on that, but you know, it just seems to me that
Right.
if you have to apply to the court for custody, then in some kind of place you're not looked at as a party to it. So that very well may could be true. You know, they're very well. You're not a real party in interest. They're not going to tell you any information. However, here's my thing: is it on the public record? What have they filed on the public record? That's the first thing I want to
But
see.
that should be on public record. That should be public record.
Something should be on the public record.
And but the only thing the thing that gets me is the lady told me, said, I'm not a party to the case, but you need to give me that information. But in actuality, this is public information.
I'd have to look at the state statute. What state are you in?
I'm in Florida.
Florida. Oh, yeah, that's right, Florida. Let me see that.
Yes,
Florida
sir.
Child Protective. Let's see.
And
Florida
what you're
Child.
saying? I'm listening.
Florida Child Protective Services are governed primarily by Chapter 39 of the Florida statutes. This legal framework dictates how reports of abuse, abandonment, and neglect are handled by the Central Abuse Hotline, local law enforcement, and child protective investigation. Section 39309 outlines procedures for initiating on-site protective investigations by the Central Abuse Hotline upon receiving reports of known or suspected child maltreatment. And that's what I'm saying. There had to be somebody reported it. That's the first thing.
Right.
Okay. Details
Uh-huh.
mandatory reporting requirements for all individuals who suspect abuse or neglect and regulates confidentiality and record sharing rules for protective services. That's probably why you can't get any information because they got confidentiality. They're going to protect the people who made the report. Okay. 39.302 governs the conduct and coordination of child protective investigations, face-to-face interviews, and safety assessments. So that's what we need to look at. We need to look at section 39.302 and 39.306, 5, right there. Administrative rules, operational guidelines, and child welfare policies are further expanded under the Florida Department of Children and Family Framework. Okay, so that is 302 Florida statute. Let me see right here. It says protective investigation of institutional child abuse, abandonment, or neglect. The department shall conduct a child protective investigation of each report of institutional child abuse, abandonment, or neglect. upon receipt of a report that alleges that an employee or agent of the department or any other entity or person covered by 39.0136 or 54 acting in an official capacity has committed an act of child abuse, abandonment, or neglect, the department shall initiate a child protective investigation within the time frame established under 39.1012 and notify the appropriate state attorney, law enforcement agency, and licensing agency, which shall immediately conduct a joint investigation unless independent investigations are more feasible. When conducting investigations or having face-to-face interviews with the child, investigation visits shall be unannounced unless it is determined by the department or its agent that unannounced visits threaten the safety of the child. If a facility is exempt from licensing, the department shall inform the owner or operator of the facility of the report. Each agency conducting a joint investigation is entitled to full access to the information gathered by the department in the course of the investigation. A protective investigation must include an interview with the child's parent or legal guardian. The department shall make a full written report to the state attorney within 3 business days after making the oral report. A criminal investigation shall be coordinated wherever possible, and the child protective investigation of the department. Any interested person who has information regarding the offenses described in this subsection may forward a statement to the state attorney as to whether prosecution is warranted. Investigation of the department, okay, and appropriate within 15 days, blah, blah, blah. The department should find the subject of the report by continued contact with the children. Okay, if in the course of the child protective investigation, the department finds that a subject of a report by continued contact with children in care constitutes a threatening harm to the physical health, mental health, or welfare of the children, the department may restrict a subject's access to the children pending the outcome of the investigation. The department or its agent shall employ the least restrictive means necessary to safeguard the physical health, mental health, and welfare of the children in care. The authority shall apply only to child protective investigations in which there is some evidence that the child abuse, abandonment, or neglect has occurred. A subject of a report whose access to children is in care has been restricted. A subject of a report whose access to children in care has been restricted is entitled to petition the circuit court for judicial review. The court shall enter written findings of fact based upon the preponderance of evidence that child abuse, abandonment, or neglect did occur, and that the department's restrictive action against a subject of the report was justified in order to safeguard the physical health, mental health, and welfare of the children in care. The restrictive action of the department shall be effective for no more than 90 days without a judicial finding supporting the actions of the department. Okay, so they got 90 days.
Okay, it's been over 90 days. They came and got my grandchildren just before Christmas. I'm talking about a week before Christmas.
Okay, yeah, well then right here it tells you what you need to do. You need to petition the court and take them in the, like I said, I'll take ChatGPT, run all this section through ChatGPT.
Yeah.
And then find out.
I did that too. I looked it up. I did look up section, what was it, 39? Yes, sir. I did look it up. And I got some papers that I had printed up. And these are the things that I'm going to go by when I write this petition to the court. So, yes, I really appreciate that once again. Yes, sir.
I appreciate it. I'm putting something in.
I was trying to handle this situation over the phone, and you just shine new light on the subject. It should be in black and white. You know, sir?
Right. So, yeah,
yes,
I'm putting this in chat right now. Let me see. Proceedings related. The statute by itself does not authorize CPS to simply take children away whenever it wants. It establishes procedures and limits for investigation involving institutional child abuse, abandonment, or neglect, such as abuse occurring in licensed facilities, foster care, school. Here's the points I would make on your call. Right. It tells the Department of Children and Family when it must investigate, who must notify, how quickly it must act, and how investigations are coordinated with law enforcement and state attorney. It's not a blanket grant of authority, but permanently remove children. Due process is built into the statute. Several provisions recognize judicial oversight. For example, a person whose access to children is restricted may petition the circuit court for judicial review. The court must make written findings based on the preponderance of the evidence, and restrictions generally cannot continue beyond 90 days without judicial findings. So after 90 days, there should be some judicial finding. If there's not any judicial finding on the record, that is of concern. But that might be due to your part of you not filing, requesting a judicial review of their actions.
Okay. That explains it all. You really shine new light on that subject, sir. Because I was going about it the wrong way. Okay, I was trying to do this over the phone, and it don't work like that.
No,
Okay.
it doesn't. No, it doesn't.
Yes,
But
sir.
but
Yes, sir. Well, yeah.
that right there
But
may
like
be
I
able to
said,
help you out.
oh, you've helped me out a great deal. I don't mind right now, but sir, I had to do that with the judge. As a matter of fact, when I was in Jax Beach, I went through trial the first time. And I
Right.
went through trial. That was the one where I was on the news. They had raided my house and all these things of this nature, and I had as a matter of fact, I went to trial with this judge name. His name was Borello. And do you know that when the second time that I got locked up again in Jax Beach for a gun charge again, I had to go back in front of the same judge that I won trial the first time with. Now, this time, he dismissed the case because he didn't want any parts of me. That's fact. He told me, look, you got a lot of talent. You need to use it.
Right.
But I'm a jailhouse lawyer. They put it like this here. All the officers in the jail know me. Yes, sir. So.
Okay, all right. That's what's up. That's what's up. That's what's up. Well, I'm glad to hear that, and hopefully that
Yes, sir.
information can help you, brother. Like I said,
I appreciate you
I
very
would,
much.
if you have any of the court documents or any official documents, I would definitely run that up through ChatGPT. Give it all the information, and then let it kick you out a petition. It can actually draw up your petition for you for judicial review. Have it draw it up
Exactly.
for you. Okay.
Yes. Okay. I really appreciate you, sir. May God bless you always.
Okay. You have a nice day.
Yes, sir.
All
You
right.
too, sir.
All right. All right. Let's get back to the.
Hey, don't forget to look up my name now. Don't forget to look up my name, Brian Keith Jimerson,
Brian Keith,
Senior at Jack Beach.
Brian Keith Johnson, got you. It's on the air.
Jimerson.
We got it recorded right here on audio, so it's recorded.
Okay, got you. Yes, sir. Take
All
a look at it, though, sir. You'll be proud of yourself.
Okay.
Pat yourself on the back.
All right. Okay, let me go back to Florida again. 561 area code. 561, Florida. 561 area code. Area code 561. Florida. Five 561-8138.
Oh, hello?
Yeah, you're on the line.
Joseph L., my brother.
Hey, what's going on?
And peace, God.
Peace.
It's an honor. It's an honor. I've been a steward for a few years now on your channel.
Right.
Right now, really, I just have a question in regards to a case I went through last year. I kind of want to know what happened. The case was dismissed, but I don't really know the actual reason.
I don't know the reason it's dismissed either. How am I going to know it was dismissed? It was dismissed. You should just be happy it's dismissed. They tell you the reason for it.
No, I'm happy.
They usually tell you the reason for the dismissal in the order from the judge. But you're saying they didn't tell you the reason for the dismissal?
Yeah, I guess that's what I want to find. I want to find the order of the judge and see what was the reason.
Okay, well, then get your case number, go down to the clerk's office and ask them for a copy of your file. They have to give it to you. It's public information.
Oh, okay. I didn't know how to get that information.
Oh, yeah, you just got your case number, whatever the case number was, the clerk's office, and go down there and say, I'd like to get a copy of my case file. And they'll give it to you. And in there it should be the order from the judge.
Right. And it should say, specify what was the main reason of dismissal.
I mean, usually, sometimes, they may have a ruling or order. They won't give specifics. That happens sometimes, but the majority of the time, yeah, they tell you the exact reason why they're dismissing it. And it's usually some either procedural rule or some substantive issue that have been met, but I don't know. I don't know. I don't know why it was dismissed. Why, if y'all just want me to start speculating. I haven't seen your paperwork. I haven't seen anything. I don't know what your
No.
case was about. I don't know why. I don't know.
Yeah. No. I was hoping that we can look into the case, but I guess
I can
need
look.
that
I
piece
can
of
look into it if you
information
give me the paperwork. Yeah, I can look at it. If I got the paperwork, I can look at it. But I can't. You just want me to speculate right now why your case was dismissed? I have no idea why it was dismissed. I have to look and see.
Right. And that I can't look over the website online.
I don't know. Some places that they will allow you online access, and some won't.
But I know you've been you do like the case evaluations and stuff like
Yeah, I evaluate it for you, but it just depends. Some jurisdictions allow you free access, online access to court paperwork, and some don't. Some make you pay for it. Like Georgia makes you pay for it, but other people,
Right.
some places don't. It just depends. I don't know about Florida, but all I know is you can get it. If there was an order, you can get a copy of it.
Okay, I understand now. I understand. I appreciate you. I appreciate that information.
I have, okay. Hey, you're welcome. You're welcome. All right, look, I got to go to the next call, okay?
All right. Enjoy the show. Thank you so much for all the information and the work.
You're welcome. You're welcome. All right, let me go to the next caller real quick. 614 area code. Where is this? Is this Ohio? Yeah, it's Ohio. 614. 614 area code, Ohio.
Greetings, Yusuf.
Hey, what's
How
going
are
on?
you, brother?
Hey, how you doing?
Well, I'm all right. Thank you for taking my call. I want to make sure that I'm on the right track with the IRS frivolous filing letter. Is there a template or something along that line to make sure that I'm going in the right direction?
What did you get a frivolous filing letter for? That would be the first question. What did you get it for?
We had a natural disaster to occur, and I had previously filed some of my taxes, but once I got situated about a year and a half later, I filed again and just simply did not know to confirm that I had filed it, honestly.
All right, well, let me just say this
And
to
so
you.
they
I'm
sent me,
listening to you. I'm not a tax expert. I can refer you to my CPA and he can answer that question for you. Now, if it was a matter of
okay,
discharging debt and you received a frivolous filing letter, I probably could have your recourse for you in that way. But in your particular situation, I'm not a CPA, so I don't know. I'm not a tax expert like that. So I don't know exactly what it is,
okay,
what recourse you're supposed to do. But I have a CPA. If you email me at admin@SBC University, I'll be happy to connect you with my CPA. He was a CPA for Price Waterhouse. He's a big time CPA. Has helped a lot of people. Hell, I had Chaka Khan's people come to me, and we were able to help her with a tax issue. So I'm sure that
okay,
if you have something, some sort of tax issue, we can help you with that.
okay. All right, thank you for taking my call. I appreciate it.
All right, you're welcome. All right, y'all. Let me go
Goodbye.
back to the next caller. Let's go to area code 650, California. California.
Peace to the God.
Peace to the gods. What's happening? What's going on?
All right. So I plan on applying, filling out my application for my passport, and I have your video say your right to a state national passport. Is this video still valid for doing that? And
Yeah, it's still valid to doing that. Wasn't that my process?
Do before?
Okay, let me say this. Do you know why I put that video? Do you know why I put that video up?
Right off the top of the head, I'm gonna say no.
Okay, I'm gonna tell everybody again, even though I've told this story 100 times. All right, I have been doing this for a very long time. Okay, Copper Moonshine and Steels has been on the internet probably since 2010. It's been on the internet a long time. That passport process has been on the internet a long time. Because in this space, everybody's always looking for processes, some sort of new process to sell someone. Another person came across the website and they got his information and started charging people $2,000 a pop for a passport program. When it came across to me, I said, damn, he just stole copper, my dude's stuff on copper moonshine steels. I said, here, let me just read it off of there so everybody will know where it's at. I had no idea it was going to do what it's done. That video went viral, probably 750,000 views. And here we are, about 7 years later, people are still talking about authenticating the birth certificate and getting a passport. All right, but that never was my intention to say this. The only reason that I gave sanction to it is because you were getting a passport without the driver, without a social security number. You used to do that. You can't do that anymore. They're going to require the social security number. They have changed their process, just like the DMV has. And now it states that if you've ever been issued a social security number, you must apply it. Now you have the group. What is that group? That tax protester group on the internet. They are Fam Guardian. Fam Guardian. They have a passport process where they actually have a letter that you submit with it, where you make an explanation for everything. But I'm just going to say this. What do you think you're going to accomplish by getting a passport? Let me ask you that. The passport in this way, what do you think you're accomplishing?
Other than not having to get the real ID, I guess me just being.
Why do you think you don't have, why you think you don't have to get a real ID to do what? To drive, to operate a motor vehicle? You think you get the passport, you don't have to have a driver's license?
Flying.
Huh?
As far as just flying, and I guess that was kind of a hiccup when I did travel to Miami. I didn't have the real ID, but they took my driver's license at that moment.
Well, what I want to know is, okay, do you think that this in some kind of way changes your status effectively? Because listen, this is what I'm trying to.
No. Okay.
So why are you concerned with how you get the passport? In other words, okay, let's say this. Let's say that they accepted your passport without a social security number. Now you got a passport with 7 stars on it. I don't know where the hell they got all this information about these stars on there. That shit just, I remember when they started saying that. To this day, I still don't know what they're talking about with that. But when you got this passport, what happens now? Now that you got this passport, you didn't have to provide your social security number, and you don't have a driver's license. You got a passport. What are you doing with that, and what do you think it protects you against?
I don't know if I'm looking at it as a protection. First thing in my mind is like, you could saying this is the better way, and I'm like, all right, roll with it. I have been following you for a while.
Listen, I'm gonna say this. It's okay to change your status or do these things that you're doing, but it means nothing if you still are participating in public regulated activity. Okay, I've told people this. It's substance over form. All the law utilizes that principle. In other words, what that means is they don't care about the words you use or what you declare yourself. It goes off of your conduct. If you're claiming you're private, but you're still in the public, they don't care about what your paperwork says. They don't care if you got a passport without a social security number. They don't care if you're a private state national. They don't care about any of that. Okay, you're claiming to be something that your conduct does not reflect. All right, and they're going off of conduct. So if you are operating and thinking that just because you got a passport or a driver's license in some kind of way you're immune from something, that you're going to end up like one of those people on the video, the thousands of them that are right now on YouTube getting knocked in the head, pulled out the car and dragged into court and put into prison. They don't say that I told you anything else out there, all the people listening, because I'm telling you what it is right now. You don't understand the difference between public and private. That's why y'all are paperwork bandits. Y'all think paperwork is going to save you. The only thing it's going to save you is the change in your conduct, not paperwork.
So that has to do with my follow-up question with this. I was going to ask you, is there a process I need to be trying to do before I even go with it?
Yeah, I would, yes.
And I do
private ordering, what we've been discussing. You need to be, first of all, what type of property do you have in your possession? What's in your name? Do you have a car in your name? Do you have where you live in your name? Like my place, I don't have anything in my name. Nothing. Not credit cards, not automobiles, not apartment complexes, nothing. is in my name. Hold on.
I get it. Yeah.
I'm sorry about that. Yeah, but nothing's in my name.
Are you good?
So what I'm trying to say is this. What I'm trying to say is status correction, what y'all call status correction, means nothing unless it comes with a change in your conduct. For instance, you just can't say I got to trust. See, that's what a lot of people think. They put a trust on paper and say I got to trust. That's form. That's not what controls in the court. What controls in the court is the substance. When they get the trust, the next thing they want to see is the trust minutes, because they want to see the actions that the trustee took and whether or not those actions are in alignment with the trust indenture agreement. Okay, so you're going to need a private trust. That's one of the things you're going to need. That's like essential. How are you going to structure yourself so you can appear in a certain capacity if you are held into court? The object of the game is to conduct your affairs in such a way where you never have to go to court. And that's the skill in learning how to navigate in the private arena. But it don't have anything to do with declaration. See, the problem in this space, everybody thinks that a piece of paper is going to save them. They've been doing that for 50 years. And it's been wrong the whole time. I've been hollering public versus private since I came to the door, and ain't nobody been listening. Everybody been like I'm a stupid person or I'm crazy or something like that. You want to get people to come debate me and stuff like that, and you don't even understand public versus private. How in hell or you have any chance in hell of winning a debate against me, and you don't know something as simple as public and private? It all starts with that.
Sure.
It all starts with that. If you understand that, and no process that you're doing is going to work. And I've been saying the same thing since I picked up a mic. You got dudes back in the day.
I've been following through the blog talk.
I've been saying the same thing since I picked up a mic. They ain't never studied the fundamentals. They want to rush straight to the remedy. They want to go straight to the remedy. That's what everybody wants to do. They don't want to study nothing. They don't want to read nothing. They don't want to understand nothing. They just want to assert something, and if you don't do what they say you do, you evil or somebody wronged you in some kind of way. But there's never a consideration that maybe I just didn't know what I was talking about. Maybe you didn't know what you were talking about. Maybe you were wrong. You ever think about that? That's not a consideration, huh? These people, like how somebody gonna come and debate me. I've been doing this for 20 years. That this is the insult. So I just been stupid 20 years, huh? You got some new guy that could come in. He's super genius. He figured it all out. And for 2 years, 20 years, I've just been wandering around in darkness. I got it. Okay. That makes sense.
That's the keyboard warriors in your comments. I know what it is.
Say what?
That's some keyboard warriors in your comments. I be seeing.
Oh, I know. I wasn't talking directly to you. I'm just making a statement, like
no,
you know,
no, I know, brother.
Like they go name these people. Like last call, dude talking about Brother Truth. I don't have any problem with Brother Truth. But if you're gonna come on my platform talking about somebody debate me, then I'm gonna have to crush him in front of you because you're stupid. You're too stupid to understand who I am. You know, just because you don't like me, I sit there and explain this for 2 hours straight. And he waited for 2 hours just to say somebody else is doing the X, Y, Z. And I have everything in the paperwork is supported by authorities. And they will say, well, you say it. I didn't say a goddamn thing. I'm reading what the law says, but they don't read the law. It's like they don't possess a certain amount of intelligence. That's what I'm seeing in this space. This space is running over with people who are not, this is the group of people who didn't do well in high school. You know what I'm saying? In high school, they just really didn't go to class. They got in English, they got D's and F's all the time and things like that. Now they're out here in the public trying to teach and understand law. But they never even mastered the 8 parts of speech. They don't know what a noun is, what a semicolon is for, how to capitalize a word at the beginning of a sentence. You don't have any of that, but you're going to come and debate me about something. Good luck. Good luck on that. This is law. Law is about precision. Laws are not about how you feel about something. Law ain't about any of those things. Law is about it either is or it isn't. There isn't any in between. And everything begins with public and private. If you go get a passport, that's fine. You got to make sure that all your affairs are still privately. But if you think that you're going to get this passport and you're going to come into a public regulated space and in some kind of way your status is different, vice versa, the public officials and everything, they don't respect that. They respect private people who know how to govern their affairs privately. That's who they respect. They don't respect private people who are stupid and don't know when they are not in the private and they're coming into the public and think that they're exercising some private right. They're going to lock you up. And yeah, they're going to give you some sort of mental evaluation. And I understand why now. At first, I didn't understand it, but I understand why they take a lot of the actions that they take. I'm on the internet. Why don't y'all look at all these court cases? Why don't y'all put in Google right now, sovereign citizen fell in court? You'll be watching videos till the end of the year. And it's no exaggeration. That's not an exaggeration. It's not an you ain't gonna see it in the echo chambers. I'm gonna do a review of a video right now. Matter of fact, let me hit you back, man. I'm gonna do a video review right now. I hit you back.
Okay.
All right. What I'm gonna do right now, this case right here. This is a case. And I can't stay on long, but I want to do this to give y'all an example. This is an example of what I'm talking about right here. Oh, excuse me. Where is this case at? Crash out. Is this a sovereign citizen? Yeah, this one right here was pretty good, though. I actually saw some cases where dudes were doing pretty good in court. I actually saw some cases where like some dudes were like, I kind of like that. So I did see some. I'm not gonna say everybody. I did see some that, I think this is one right here. Is this where he tried a special appearance? Yeah, let me look at this right here. This is not the one where dude had the criminal case though, but this right here is pretty. Let me see if I can just upload it real quick. I'm gonna take another call while I'm setting it up. I'm gonna take another call while I'm setting it up because I know this might take me a little time to set up. Let me see. Let's see. I'm gonna just start posting these videos on my YouTube channel, man. So y'all can just start watching them. I'm just gonna start posting them so y'all can watch them, man, because they crack, What is the thing? I don't know MP to MP4. What is it doing, man? They gave me I didn't ask for that. What is this? Let me go back to the phone line real quick while I'm setting this. I'm gonna take one more call while I'm setting this up. 904 area code. What? No, it's 407. 407 area code. You're on the line. 407 area code.
Yo.
Hey, what's happening?
Yes, sir. My brother, what's going on to the God?
Hey, peace to the gods, brother. What's happening? What's going on with you?
Man, I'm just chopping in, checking in with you, man. I think the last time I called in, it was about 3 years ago, man. But I just want to say, you turning up. I see you on your digital. Hey, man, I appreciate the quality. I appreciate how you turning up on the way you present these videos, getting them titles real, controversial for them folks to come on in who got them emotional problems about changing their minds about real truth. You really you touching nerves, boy. I see what you doing.
I mean,
hey, I appreciate it. Hey, I appreciate it, man. I'm gonna be in class with you tomorrow night. I'm telling you.
Okay.
You're doing it. I'm gonna be in class with you tomorrow night. You're doing it. And I just come up to tell you, man, to just give you some encouragement, my brother. Truth is definitely has to face resistance. Has to. The only way truth can continue to rise is that somebody come and challenge you. And so all the challenges I see folks coming and challenge you with means to me that the truth is really hitting home, my brother, and don't stop. It's folks out here who really, they don't say nothing. They're in the bushes like me. They really are feeding off what you're saying. I just got off my rusty crusty to spend some money, start putting some energy your way. Because, you know, I don't agree with everything you say, but the things you say that's relevant to my life and any case or debt I'm dealing with, it definitely
Please come up to the podium
encourages
so you can.
me to look within me to find the answer. I don't look outside no more. I can't. It ain't nothing out there. I done tried that.
Everybody's tried
all
that.
the answers.
That's right.
All the answers are on the inside, and you have provided that. Go ahead. I see you got that on. You wanted to run that case. Go ahead. Let's run that case, man.
Okay, yeah, you can stay on the line with me. I'm gonna run this tape, y'all, and we're gonna look at this case real quick. This is an example. I think dude was doing okay. I got about 3 videos like this to review. As one that I really want to review because it reminds me so much of my situation that I went through, and I'm going to look at it. But this one right here, it's pretty interesting. Let's take a look at this one right here.
Please come up to the podium so you can be on a microphone. Otherwise, your statements won't be recognized.
I'm Anthony Meyer. And appear by special appearance to challenge jurisdiction.
Wait until you're at a microphone, sir, so you're being recorded, please.
Okay, very well.
There at the podium.
Approach special appearance only, not as the named entity.
Come on up to the microphone, please. Let me ask, are you Anthony Meyer? Yes or no?
I am Anthony Meyer and appear by special appearance to challenge jurisdiction and confirm administrative default to avoid joinder. And I am approaching under special appearance and not as the named entity.
This is the case of the People versus Anthony Meyer. Are you Anthony Meyer? Yes or no? And that will determine whether or not there's a failure to appear today.
I am, Your Honor, I stated that I am Anthony Meyer.
Okay,
Hereby
so,
special appearance.
Mr. Meyer, you've already
Objection,
made your statement.
objection.
You've made your
You're
statement.
interrupting me, please.
You've already made your statement this morning. Now,
Anthony
we need to
Meyer,
reset
and
the case for
hereby
trial.
Special.
You've already
appearance.
said that, right?
I'm only here to settle the accounting.
So you have 2 options. You can go to trial, or you can plead guilty or no contest to the charge of no insurance. You want to have the
I'm
case
here in-
reset for trial? Yes or no?
I'm here in honor to settle the matter.
Then let's settle it. If you want to know proof of insurance, you can take that. If you want to go to trial, you can do that.
Can you have the DA read the charges into the record?
You're charged with no proof of insurance. You can plead guilty, no contest, or proceed to trial again.
I don't see any proof of the charging instrument.
Oh, okay. See, he's just screwing up. Okay, first of all, you want the person who is bringing the charges to read the charges into the record because that's the person that's liable. He's making a lot of mistakes right here. You know, he's supposed to get Your Honor, objection, Your Honor, but am I to understand the honorable judge has made a judicial determination I'm not to be afforded my due process rights of hearing the charges read against me by the person who made the allegations against me? Something like that. You know, these are tricks. Like what's happening right now is something that you see all the time. This playbook that they're going off of is old. You know, it's not anything new. So what it's going to get to the point where it just seemed like he's just reading from a piece of paper. See, this is the reason why it's hard to read from a piece of paper when you need to be conversant with this information. Because see, I don't need a piece of paper. I go into the courtroom, I don't need to be stand up on the podium with a piece of paper. I can sit there and just talk right to the judge, just off the top of my head. Everything that I need to say, everything that he says to me, I'm going to have an answer for right off the top of my head. Because I'm conversant with the information. See, this is what happens when you're not conversant with the information. And all he's doing is just reading off things and not really paying attention to the responses of the judge. He's not paying attention to when he needs to preserve an error and form an objection or anything like that. He's just going down the line and just reading things. Let's keep going.
Okay, can I chime in right quick there, boss?
Yeah, go ahead.
I'm just saying, if I'm put in any position like this here, what I've come to understand is them folk don't want to hear nothing about no philosophy, no, not, they want to hear how, because when they say trial, they talking about the trial of the terms of the agreement to pay the charge.
No, when they say trial, they say you are arguing the facts, because the only thing trial is for is to do fact finding, to determine what the facts are.
Well,
So you don't have an
well,
agreement. You don't have an agreement in place of what the facts are. So they're going to have to determine what the facts are.
right. That's what I'm saying. The terms of agreement is the trial.
Well, there
That's what's
isn't
going.
it, there is no agreement in place. You keep saying agreement, but the reason you go into trial because there is no agreement.
No, what I'm saying. That's what I'm saying. Trial is to work out the terms.
Trial is to determine what the
Because
fact.
there's a payment.
Okay.
There's a payment. There's a payment due.
Well, if there's a payment
So,
due, then you don't want to argue any of that. That's what I'm trying to say. If you're going
right.
to trial,
That's my point. That's
you
my
shouldn't
point.
even be going to trial.
Right. That's my point.
The first
The
thing you
whole
should be
point of
saying
being
is, I'm not arguing any facts, Your Honor. I've stipulated to all the
Amen.
facts in the charging instrument. All the facts have been stipulated
Amen.
to. I'm not arguing any facts.
Amen. 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 I'm saying, if I'm in front of a judge, only thing to talk about is how to discharge, right? I'm gonna just help me.
Well, there's a way that you need to present that though, too. You know, you got to, you're coming in and, I mean, how he's doing it, I guess, is okay. But like I said, he's reading everything off of a piece of paper, which is better than nothing. I'm not, going to say it's the worst thing, but you should be able to be conversant with this information if you're going to go into court. That's not a good look to be reading it off a piece of paper. It just never is. It just never is.
Right.
It looks like if I were a judge, I would know you don't know it. I say, you don't know this like you think you do. I can trip you up.
Right.
I know I can trip you up. I know I can ask you some trick questions and you're not going to be able to follow because you're having to go off of a piece of paper.
But the whole point of being in front of a judge is to deal with the charge, right?
The whole point, it's a hearing officer and they're dealing with
Right.
an accounting, a book entry accounting. That's his approach
Yes, sir.
that he is attempting to use right now. He is. Let me hear the rest of it. I just want to hear what he's going to say.
Right.
They just been into it 2 minutes. Let's see what he's going to say.
And
You
or
were
any
issued a
Yes, sir.
summons and
certified
complaint
accounting.
that's adequate to inform you of the charges. You test or stand by the not guilty plea that was entered by the court on your behalf, and we will reset the case for trial. How would you like to proceed?
Before this court can proceed, the plaintiff must rebut the administrative judgment and provide a verified claim by the party with firsthand knowledge.
That's inaccurate. We're going to set it for trial again.
Jurisdiction remains unanswered, and there is an unrebutted administrative judgment on the record.
See, all he's doing is just reading down a list. He's making things a part of the record, but he's just kind of just reading down a list. He's not really, it's really no like response to what, because the judge said I entered a not guilty plea into you. My response would have been, Your Honor, I'm not arguing any facts. I'm stipulating, I want the record to reflect that I'm stipulating to all the facts in the charging instrument. I'm not here to argue any facts, Your Honor. I'm here for settlement and closure of this accounting. And then we can get into it, because then that locks them in, because now they can't take you to trial because you're sitting there saying I'm not arguing any facts. So they go, well, what do you mean? You're going to plead guilty to the charges? Well, no, not, Jan. I'm not saying I'm pleading guilty, because you got something called a confession and avoidance. Okay, that's what acceptance for value was in the commercial world. All right, where you can actually admit to the facts, but plead other facts that render those facts inoperable. That's what the acceptance for value approach was attempting to do. But where y'all get caught up at is you go in there arguing facts. And you ain't gonna never win arguing facts. You're gonna have a 0% win rate arguing facts. Fact finding and arguments are for attorneys. Even the Bible warned you against that in Matthew 5:25, where it says, agree with your adversary while you're on the way to court. These your adversary, you hand you over to the judge hand you over to the bailiff, and the bailiff cast you into prison. I tell you, you will not come out until you pay the very last penny.
Amen. Amen.
I mean, if
That
Jesus
was my
can't help
point.
you, I can't help you. Jesus can't help you. I mean, how am I gonna help you if
That was
Jesus
my
can't help you?
My point was what you said. My point was what you said. It got to be something about dealing with the charge, accepting it for value, dealing with that. That's
They
it.
want to
That's all
deal.
I would be in court
They
for.
want to deal with the facts. All right, so it's either their business going to be going on or your business going on in the courtroom. They want to talk about what you did in the facts. What you did in the facts is irrelevant. What you're trying to address is the issue, the real issue. The real issue is what? That there is some sort of bond or there's some sort of obligation
Yes, sir.
that's aging on the books. All right, that they are looking for some sort of performance by. That is the position that he's taking right now. So let's see how well he does it. Let's see how well he does it. Let's just see.
And I request for dismissal.
A motion to dismiss denied. Let's set it for a jury trial on, I got speedy trial restarting as of today's date.
Your Honor, for the record, I do not see the officer present in the courtroom, and without a sworn complaining witness with firsthand knowledge, I move the matter to be dismissed.
Motion to dismiss is denied. The officer does not have to be here today. We're going to set it for jury trial on May 7th
I have,
at 8:30.
Okay. I've heard them say that a lot, but I would ask for some sort of evidence of objection, Your Honor. Could you please provide me your statutory authority that permits you to make a ruling that states that the officer does not have to be present during these proceedings? I'd just like to get that in writing. Anything that you don't object to, you admit to. Anything you don't object to, it flies. If you don't object to it, ain't nothing they can do. This is how they trick most of you, that you don't know what to object to and you don't know how to form an objection. That's why there's a document called Court Tricks and Traps out there, because they usually get you procedurally and play with you like a cat that's playing with a mouse because they know you don't know what you're doing. Let's keep going. Look at
I've
this.
yet to see an offer from the DA. Can Mr. Epson please read the charges into the record?
The offer is no proof of insurance.
Okay,
guilty.
can I see those charging instruments and the certified accounting for that?
We're done.
I do not see the certified accounting for the charges or the charging instruments, and I again request dismissal. I'm here by special appearance to confirm the administrative default. I've given you guys the motion, or sorry, the notice. I've given you guys the notice, order, and the motion to dismiss, and I've also put into the record an acceptance of offer. And again, Anthony Meyer, the living man, accepts the presentment of the offer for the case number 23T0294 to set off, settle, discharge, and close all accounts, including but not limited to the equitable subrogation, IRS 941, the 941V, the 1099A, C, and OID, or supplied supersedes bond. I, Anthony Meyer, the living man, does not consent to go to prison on behalf of the named defendant, estate Anthony Janae Meyer.
Mr. Meyer, your motions are non-persuasive and essentially gibberish. Motions to dismiss are denied. The case is being reset for jury trial. You've seen what happens if you pull this at a jury trial. It will register as a failure to appear. A new warrant will issue, and we'll keep going through this
I'm here in
until
honor.
you show up and acknowledge in front of a jury that you are Anthony Meyer. So again, you can go back to trial. We've set a trial date, or you can plead guilty or no contest. Last chance. Want to set it for trial? Yes or no?
Again, I'm here by special appearance to challenge
We're
the
going to
jurisdiction.
trial May
and to confirm
7th
the
at
administrative
8:30.
default.
We're going to do a status pretrial conference with a mandatory appearance.
I'm here in honor. And the DA has yet to present me anything, no offer, has showed no proof. Officer is nowhere to be seen. I'm present right here in front of you. You're saying that I'm not here. I'm
Judge, for the
telling you that I'm
record-
here especially.
For the record, the officer was here
No,
on
he wasn't.
Thursday. Both officers came in from, one came in from Florissant, one came in from Park County.
The Officer
Then
does not,
these
Mr.
officers
Meyer, the officer
but
does not
provocative.
have to be here today.
He's
You
never been
are-
here for
He was-
not the arraignment, not for the hearing, nor was he here for the jury. And then you
Had-
said that I wasn't here last time when I was present right here in front of you,
I called
telling
for
you.
Anthony Meyer twice. You refused to have a seat, so I found you failing to appear to be tried.
And I was telling you that I'm
Had
here
you
by
taken
special
your
appearance.
seat, had we sworn a jury and had the officer not appeared, it would have gotten dismissed. That didn't happen because you failed to take your seat at the defendant's table. So
I was willing to take my seat,
No,
Your
you
Honor. I
were
just
not.
wanted to let you know that I was here by special appearance to settle the matter.
Okay.
And again, today I'm here only.
Basically, the judge just told him we was going to dismiss your case. All you had to do is sit down. When I would have called it, you could have got it dismissed then, but you didn't. We were offering, if the officer is not there, all you have to do is wait. And yeah, you could get it dismissed, but you didn't do that. That's what that's the message the judge gave him. And by the way, that is one of the ways, like, they do get rid of your case. A lot of times, y'all looking for something to be straight on the record, them saying, yeah, thank you for your bill of exchange. We appreciate it. We're going to dismiss the case for you now. You're absolutely correct. You're a private state national, and we're selling bonds behind the scene. You got to be a fucking idiot if you think that they're ever going to admit that and put that on the record. Some of you don't need to be doing this. You don't, because you don't understand public and private. Y'all have gotten so far away from the original teachings of this, it's ridiculous. Y'all just going into, you're not exercising any kind of privacy whatsoever. You're looking for somebody to expressly tell you something, and that's never going to happen. They offer doorways out and things like that you got to figure out. This is what I mean about somebody who's experienced versus somebody who's never been in a courtroom before, but you're going to sit at his feet and listen to this person try to tell you on what you should be doing.
To settle the matter.
the only way to settle it is to plead guilty or no contest.
Are you practicing law from the bench?
No.
No, I'm
Okay,
making the
we're
offer.
done.
Consider a plea on my behalf the first time.
As the statute authorizes, if someone refuses to plead, the court can enter a not guilty plea.
He made an objection, but he never ruled on it.
So head down the hall, they'll get your paperwork. We'll see you here in person, March 4th at 3 o'clock for a pretrial conference. And the case is set for jury trial May 7th at 8:30.
You guys have my offer, and so I'm waiting for the certified accounting and for the instrument for this to be able to proceed forward. So
Don't hold your breath. Go down the hall to the
We'll be
clerk's
the same.
window. Thank you.
Thank you, Your Honor.
All right, let's go to Mr. Anthony Meyer. Case number 2023 T294, appearance on bond. Case is currently set for jury trial. Take two on May 7th at 8:30. Good morning, Mr. Meyer.
Good morning, Your Honor.
Any questions to begin with?
I, Anthony Meyer, am appearing specially, not generally, on behalf of the named defendant estate, also known as Anthony Janae Meyer, here to challenge jurisdiction and to confirm the administrative default and to avoid joinder. And only here to settle the accounting.
So to summarize your options again, of course, you're presumed innocent. We have you set for a jury trial. Other options to enlist the services of an attorney or plead guilty or no contest to the charge. Mr. Ibsen, is there a stipulated plea offer regarding any potential jail time?
Judge, I was going to make the defendant a plea offer actually, I was going to offer a deferred judgment to no proof of insurance for a year with 60 days jail suspended on condition that he provide proof of insurance to the court every month. Court of probation.
So there's a plea offer that includes a deferred judgment with
Okay, this is when it starts getting into like muddy waters and everything. Then you start seeing it making offers like this. And it can be an indicator that you got some sort of leverage, all right, that you are leveraging because of things that, and it will start to look like this. These are the things that you'll start to notice. All right, well, look, just go get your insurance and just show that for 60 days. Like that's what cost because it's costing you to provide that every day. Like, no, I don't want any cost on anything. But I think you should have insurance. So this gets down to the question of, do you have to have insurance? Yes, I think you should have to have insurance, but some people don't think that you have to. So, because what if you hit someone or kill someone and you don't have any insurance? You think you're going to be able to, I'm here to settle the matter out of court. You think you're going to be able to use that in that situation? I can tell you that it's not going to happen. It's not going to happen like that.
required ongoing proof of insurance, or you can plead guilty or no contest with a fine and court costs, 4-point assessment against your driving privileges, or of course, carry on with the jury trial scheduled in May. Mr. Meyer, of those options, do you want to continue with the trial setting?
I would say at this time, I have put in the notice motion in order, and before the court could proceed, the plaintiff must rebut the administrative judgment and provide a verified claim by the party with the firsthand knowledge. And would like to see if I could have a written response to my offer and 72 hours to review with my attorney.
You do have the right to discovery. Have you requested that from the DA's office?
I have not.
So you can make a request for discovery. That'll give you the police reports and other discoverable information in the file, any body cam video of the incident, anything that the state has to provide to you under Rule 16. Then you can assess that evidence and decide how best to defend yourself at trial if you want to continue with the trial. You do have the right to confront any of the state's witnesses. That right means that at trial, those witnesses would be called, put under oath, and you could cross-examine them. You do have the right to present your own evidence, though you don't have to. It's the state's burden to prove the charge beyond a reasonable doubt. You don't have to take the stand or call witnesses, but you of course have the right to if you choose to. Other than that, the court has denied your motions to dismiss. The complaint filed in the case is adequate under Colorado law to advise you of the nature of the charge, date, place, and time. So we are going to proceed to trial unless you choose to take a different path. Any additional questions today?
I would just say that I still don't understand the charges. I haven't seen the charging instrument.
I'm reading in the comment section, right? Somebody said the terms are asserted capacity. Okay, this is that sovereign citizen stuff. This is how y'all get caught up in sovereign citizen ideology. Now this Autumn Coleman 9453, you just making that shit up. What do you mean terms are asserted capacity? Your conduct is what determines how it's going to be. Your conduct gets defined, not words. The conduct that you engage in, and from that conduct, your capacity is determined, and from that capacity, it gets classified, and that classification determines rights, liabilities, duties, and remedies. It's a formula, and you're not going to get away from the formula. You can't make up your own explanation for the formula and start talking about adhesion contracts. That doesn't have anything. You're just making that up. You just made that up. There's no basis in law of fact for what you just stated. Nothing. Nothing, it's made up. Y'all got to stop doing that. Y'all, what y'all do is y'all try to, I'm going to tell you what the problem that you have to start doing. And the reason I know, because I used to do it. you'll look at their actions, and instead of looking at it for what it is, you try to throw in some sort of behind the scenes explanation for what's going on. That's not the case in every particular situation. You know, you're trying to look for every little thing they do. Yeah, he's trying to contract with me right here. You're trying to do that. That's not the situation in every particular situation. A lot of this is just a traffic ticket. Now, I'm going to tell you like this. There has to be something seriously that you need to address in your life if not having insurance and not having a driver's license is a big issue in your life. If that's your biggest issue in your life, having a driver's license and insurance, what your issue is that you don't have any money. That's the issue. And you definitely shouldn't be trying to live in a place, a convenience, a center like a city. If you don't want to have insurance, a driver's license, and things like that, you can have that, but you can't do that in a municipality. You can't. I don't know how else to say it. It's not I'm an agent or anything like this. I read the law every day. You are not interpreting the law the correct way. And if you want to get somebody to debate me, bring them, because I'm going to serve their head to you on a platter. I got time today. Like you sitting there saying, let me tell you, I've been doing this 20 years. You don't think that we've been saying that everybody, the state, that the prosecutor is the state, the judge is the state, the sheriff is the state, the police officers is the state, all that. Yeah, it is. You know why? Because you're an administrative court. They're seeking compliance. Okay, you're not in a constitutional court. You're in an administrative court. Administrative courts are seeking compliance to rules, regulations, and statutes within the public. That's what statutes govern. That's what you don't understand. That's what none of you understand. You just don't understand it. You don't understand it. But hey, you keep doing what you're doing. Keep doing what you're doing. Why would you think that statement you made, they've been regurgitating that for 50 years, and y'all been losing the entire time? You don't think you're crazy? You don't think by now that y'all should try a different approach? That this I'm not that person arguments, which have never worked. They have never worked, not one single time. Let me see if I can find a case for you. Hold on for a second. Roger Elvick, Meg 19. Well, yeah, Roger Elvick had a case. Sovereign citizen movement competency to stand trial. Let's see. Sovereign versus the people, 1983. Let's see if this is it. Jerry Sovereign plan to respond to people, defend appellate. Okay, the Central Bank petition was convicted of violating penal code. Rehabilitation petition has satisfied the period of rehabilitation. Have anybody ever seen a sovereign citizen Freeman? An analysis of the sovereign citizen movement, lose process addressing the sovereign citizens. Hold on. Let me pull this up for you. I'm gonna have to get off too, because I got some work I gotta do. But I'm going to run what is this right here? Hold on. While y'all doing that, I'm gonna let this right here flow while I'm waiting on this. Hold on.
And or certified accounting, and at this time jurisdiction remains unanswered, and there's an unrebutted affidavit or administrative default judgment on the record, and again I just request dismissal.
The motion to dismiss is denied. The complaint that you were issued by the officer is adequate to inform you of the charge. That's a charge of operating a vehicle without showing proof of insurance. It indicates the date, place, and time, that being within Park County, thus conferring jurisdiction on this court. So the next court date
shows there was a pre-trial for tomorrow. I'm not sure if that could be pushed out or could also be pushed to Zoom. I actually don't reside in this state. I'm kind of here because I have to be. And so, yeah, either if I could do a Zoom for tomorrow and or it could be pushed out a little bit. I guess there's a few additional things I could request and or file.
Okay.
Real quick, I want this to go all the way back to the 80s. And he's doing, I like the reason I pulled up this case and I like it because you get to see how all the threats and everything, how he's doing a very good job of not letting anything shake him. He's doing a very good job of that. He's not letting anything shake him. All right. And they keep talking about trial and different things like that. They keep threatening you with trial and everything, and then you end up never going to trial. But these are the reason I'm showing you this case is because he does understand the game. He's not fooled by the illusion of what's going on in front of him, and that's what I like about him. Let's look at this real quick. All right, so you got sovereign citizens. How far back does this go? Okay, if you're researching the legal origins of what later became known as the sovereign citizen movement, it's important to note that the term sovereign citizen was not commonly used in reported judicial opinions during the 1980s. Courts more often dealt with these litigants as tax protesters, posse comitatus members, common law court advocates, or anti-government extremists. The modern label became widespread in the 1990s. Here are some of the most significant cases and prosecutions from the 1980s. United States versus Call. Gordon Call, he was with the posse comitatus. He ended up, they took his life from him. He ended up losing his life behind this. Jerry Sloan, I remember him, rejected claims that wages are not income and other common tax protester theories, frequently cited against sovereign-style arguments. Kowalski, court characterized tax protester argument as frivolous and upheld the convictions for failure to file tax returns. 1985, rejected constitutional attacks on the federal income tax system. United States versus Jajin, famous for the statement that sovereign-style jurisdictional arguments completely without merit and patently frivolous. This is back in 1980s. United States versus Studley held that the claims of being a freeborn citizen outside the tax law were frivolous. In other words, they've been telling you the same thing for 50 years about those approaches that y'all have been using. About those approaches. Because when you read the law, you can see that they are correct. See, the approach is when you're looking at the money, they don't have any money. They bankrupt. All that can be confirmed and verified. But you're talking about they don't have any authority when right there in Article 1, Section 8, Clause 3, they got the authority to regulate commerce. Article 1, Section 8, Clause 9, they got the authority to make tribunals that are inferior to the Supreme Court. All of this is enumerated, so I don't know where you're getting this unlawful acting out, this de facto and all these things that you say, because it only demonstrates that you have not studied the Constitution, which a lot of people in this space haven't even read it. Don't even read the Constitution. I don't see any study groups and any of the echo chambers devoted to studying just the Constitution. Look at this right here. Historical events, not court opinions, the farm crisis. That's spread at the, that's who all y'all getting this from, these farmers. That's who a lot of this stuff started. This I'm not that person arguments and stuff. It started with a group of farmers and the posse comitatus. And that's what y'all regurgitating all the way up to today. That's the only thing that I'm saying. So yeah, it go all the way back to the 1980s. This is 1986, that's 40 years ago. I'm just saying.
Request and or file.
Okay. So you're currently on bond, the court, Mr. Ibsen, any objection to modifying bond to allow Mr. Meyer to leave the state
No, sir.
pending the trial?
No,
Okay, so the bond is not forfeit. It continues. That's $1,000 cash bond posted last time. We'll continue the bond until the case is resolved, modify the bond to allow you to leave the state. Are you residing in Arizona?
Florida.
Florida now, okay. The next court date that the court is showing is the jury trial. Well, we've got a pretrial readiness tomorrow. Okay, that's what you're referring to. I propose we vacate that.
Okay.
And we just leave it on for trial May 7th at 8:30. You would have to be here in person for that.
Oh, yeah. And could I add one more thing?
Sure.
Hey, the dude who said bullshit in the chat, the phone line is open, bro. You can call me in and I can go ahead and destroy you and embarrass you in front of the entire world if you like to. All cap, false prophet. You want to come in and everything, grab the phone line, bro. Come grab the phone line. Let your nuts hang. Let your nuts hang a little bit. Let your nuts hang. You're going to write something, you keyboard gangster, right? Go on, call in right and tell me why it's bullshit.
I would like to motion and order this court to revoke and revest the court's case trust securities. And I am motioning and ordering the court and the state to produce the IRS 1099-A QSIP, bid bond, performance bond, and payment bonds for set-off, settlement, adjudication, adjudicate all claims, balance all the accounts to zero, discharge and close all accounts, and
Look, I got
return
to get off here
remain
today.
funds to me
I
and
got
dismiss the
some
case with
business to
prejudice.
attend to.
Um,
I'm gonna start posting these.
unless I can get the certified accounting, just
cases and
because
just let y'all
this would
watch
be
them
a
and y'all come to your
concealment
own
of my tax
conclusion
records.
on them. I'm going to start posting a lot of them on this channel
I
because I
have
want
no
y'all to
idea
watch
what
them
you're
and draw your own conclusions from it.
asking.
And I'll post it after this.
So the motion's
But,
denied as
if you're gonna,
inapplicable,
here you go.
incomprehensible,
Please I got to get ready anyway. I got a little time.
unpersuasive.
All right, anyway, I got to go.
entirely. So the
Peace.
case remains
I'll
set
holler
for
at
jury
y'all.
trial May 7th at 8:30.